For the charge before this court, you are hereby sentenced to life in the Iowa State Penitentiary.
Life in prison? No, please, you can't do this! I'm only 18! This can't be real!
Teen sets house on fire on New Year's Eve. Family of 4 dies torch. Then she claimed it was candles. The morning of judgment. The first snowfall of the season dusted the streets of Portland, Oregon. On the morning Madison Reeves walked into Multnomah County Circuit Court to face trial for the murders of Robert Hartley, Susan Hartley, Lucas Hartley, and Emma Hartley. It was October 14th, 2021. 10 months and 14 days since the New Year's Eve fire that had incinerated a family and shattered a community that prided itself on progressive values, compassionate governance, and a commitment to protecting its most vulnerable citizens. The courthouse, a brutalist concrete structure built in the 1970s with narrow windows and sharp angles, loomed over the downtown streets like a monument to judgment itself. Its gray facade reflected the overcast Oregon sky and the flags outside. The American flag, the Oregon state flag with its distinctive beaver emblem, and the Multnomah County flag, hung limp in the cold, windless air, as if even they were holding their breath. The courthouse steps were crowded with journalists from every major news outlet in the Pacific Northwest. Camera crews from KOIN 6, KGDO 8, KATU 2, and Fox 12 had staked out positions since before dawn, their satellite dishes pointed skyward, their reporters clutching steaming cups of coffee from the nearby Stumptown coffee shop and rehearsing their stand-ups in the freezing pre-dawn darkness. This was the kind of case that defined careers. A foster child turned murderer, a family burned alive on New Year's Eve, a community forced to confront uncomfortable questions about the systems meant to protect vulnerable children. National outlets had sent correspondents as well: CNN, NBC, ABC, even a crew from Dateline NBC, who had been following the case since January and planned to air a special episode after the verdict. Beyond the media circus, clusters of protesters had gathered on both sides of the courthouse entrance, separated by a line of Portland police officers in riot gear who stood with arms crossed and expressions of practiced neutrality. On the left side, members of foster care reform organizations held signs reading "Madison is a victim to," and "Fix the system, not the children," and "Where was CPS?" They chanted slogans about systemic failure, about how the state had abandoned Madison long before she ever struck a match, about how putting a traumatized teenager in prison for life wouldn't solve the deeper problems that had created this tragedy. On the right side, family members of the victims and their supporters held photographs of Robert, Susan, Lucas, and Emma Hartley, along with signs reading "Justice for the Hartleys" and "4 Lives Matter," and "No Excuses for Murder." They stood in silence, their faces drawn with grief that hadn't diminished in the 10 months since the fire, their eyes fixed on the courthouse doors as if willing justice to emerge. Inside the secure transport bay beneath the courthouse, a white corrections van pulled to a stop at precisely 8:45 in the morning. The driver, a corrections officer named Miguel Santos, who had worked for Multnomah County for 12 years, put the vehicle in park and turned off the engine. In the back of the van, behind a reinforced steel partition, Madison Reeves sat on a narrow bench seat, her wrists bound in front of her with steel handcuffs connected to a chain around her waist, her ankles shackled with cuffs connected by an 18-inch chain that forced her to take small, shuffling steps. She wore a pale blue blouse and black slacks, clothes her attorneys had purchased for her from a Goodwill store because she owned nothing appropriate for trial, nothing that would make her look like a normal teenager rather than a prisoner. Her dark hair, which had grown past her shoulders during her 10 months in custody, was pulled back into a low ponytail with an elastic band, and her face, scrubbed clean of the minimal makeup she'd been allowed to wear in detention, looked younger than her 18 years. Her skin was pale from lack of sunlight. Her eyes, dark brown, almost black, were shadowed with exhaustion from sleepless nights in her cell, and her expression was as blank and unreadable as the gray concrete walls that surrounded her. She was 17 when she set the fire. She was 18 now, having turned 18 on April 14, 2021, in a county detention cell, alone except for a corrections officer who brought her a small cupcake from the facility's commissary. A gesture of kindness that Madison had received with the same blank stare she gave everything else. The state had decided to try her as an adult, a decision made by Multnomah County District Attorney Mike Schmidt after reviewing the evidence and consulting with the victim's family members. 4 counts of aggravated murder. 1 count of arson in the first degree. 1 count of reckless endangerment. If convicted on all counts, Madison Reeves would spend the rest of her life behind bars, with no possibility of parole, for 60 years. A sentence that meant she would be 77 years old, an elderly woman whose youth and middle age had been consumed by concrete and steel before she could even petition for release. 2 corrections officers, Santos and his partner, Officer Rebecca Chen, a 32-year-old former Marine who had joined the Sheriff's Department 5 years earlier, opened the back doors of the van and helped Madison step down onto the concrete floor of the transport bay. She moved slowly, awkwardly, the ankle chains making it impossible to take normal steps. Chen held Madison's elbow to steady her, a gesture that was partly professional courtesy and partly genuine compassion. Chen had transported dozens of defendants to trial over the years, and she had learned to separate the crime from the human being. Madison was a teenager, barely out of childhood, and regardless of what she had done, she deserved to be treated with basic human dignity. They led Madison through a series of secure corridors, past holding cells where other defendants waited for their own court appearances. A man in an orange jumpsuit who was facing assault charges, a woman in county blues who had been arrested for drug possession, a teenager not much older than Madison who was waiting for a probation violation hearing. None of them looked at each other. Eye contact in jail was dangerous. It invited confrontation, and confrontation invited consequences. Madison kept her eyes down, focused on the gray concrete floor, her face betraying nothing. Finally, they arrived at a small attorney conference room, a windowless space with cinder block walls painted an institutional beige, a metal table bolted to the floor, 4 plastic chairs, and a flickering fluorescent light overhead that hummed constantly. Madison's attorneys were already waiting. Aaron Lipsky stood when Madison entered. He was 34 years old, a public defender who had graduated from Lewis and Clark Law School 6 years earlier, with more idealism than debt, though he had plenty of both. He wore a gray suit that was slightly too big for him. He had lost 15 pounds in the months since taking Madison's case, the stress manifesting in skipped meals, sleepless nights, and a constant knot of anxiety in his stomach that no amount of antacids could relieve. His dark hair was starting to thin at the crown, a genetic inevitability that had accelerated under the pressure of this case, and there were deep shadows under his brown eyes that no amount of coffee could erase. He had been a public defender long enough to know that most of his clients were guilty, that most cases ended in plea deals, and that trials were expensive, time-consuming gambles that rarely paid off. But he had also become a public defender because he believed that everyone deserved a defense, that the system only worked if both sides fought as hard as they could, and that sometimes, rarely, but sometimes, you could make a difference. Beside him sat Jennifer Parrish, his co-counsel, a 28-year-old associate who had joined the public defender's office 2 years earlier after spending her first 3 years out of law school, working at a corporate firm in Seattle, billing 2,000 hours a year on contract disputes and intellectual property cases, making good money but feeling like she was wasting her life. She wore a black blazer and slacks, her blonde hair pulled into a professional bun, and she carried herself with the careful composure of someone who knew she was being watched and judged by everyone in the courtroom. Parrish was smart, organized, and deeply committed to the work, but she was also realistic. She had reviewed the evidence in Madison's case a dozen times, and every time she came to the same conclusion: they were going to lose. The search history alone was damning. The unsent text message was practically a confession, and Madison herself was the worst possible defendant. Emotionally blank, seemingly unremorseful, incapable of connecting with a jury on any human level. Parrish had tried to coach her, had spent hours in this very conference room teaching Madison how to make eye contact, how to show appropriate emotion, how to look like someone who regretted her actions. But Madison either couldn't or wouldn't do it. She sat through their sessions with the same flat effect, the same 1,000-yard stare, and Parrish had eventually given up. "Madison," Lipsky said gently, gesturing to the chair across from him. "Good morning. How are you feeling?" Madison sat down slowly, her chains clinking against the metal table. She didn't answer immediately. She rarely did. After 10 months of meetings, after hundreds of hours spent trying to prepare her for trial, Lipsky had learned that Madison existed in a state of profound emotional numbness, a dissociation so complete that it sometimes seemed like she wasn't fully present in her own life, like she was watching everything happen from a great distance, detached and unreachable. "I'm fine," Madison said finally, her voice flat and toneless, devoid of inflection or emotion. "We're going to start jury selection this morning," Parrish said, leaning forward slightly, her hands folded on the table. "It's going to be a long process, probably 2 days, but it's incredibly important. We need to find jurors who can be fair, who can see you as a person and not just a headline, who can understand that there's context to what happened. We need people who have empathy, who understand that trauma is real, and that it changes people." Madison nodded, a barely perceptible movement of her head, but her eyes remained unfocused, staring at some point on the wall behind Lipsky's shoulder. Lipsky exchanged a glance with Parrish. They had talked about this, about how Madison's effect, her emotional blankness, her complete inability to project remorse or vulnerability, would play in front of a jury. Most defendants cried during their trials. They showed emotion, whether genuine or performed. They connected with jurors on a human level, made eye contact, smiled weakly when appropriate, looked devastated when the evidence was presented. It was part of the theater of trial work, and it mattered. Juries wanted to see that defendants were human, that they understood the gravity of what they had done, that they were capable of remorse. Madison did none of those things. She was a closed book, sealed tight, and that made her unreadable, unsympathetic, and ultimately very difficult to defend. "Madison," Lipsky said, his voice firmer now, taking on the tone he used when he needed her to actually listen rather than just sit there. "I need you to understand how critical today is. When we're in that courtroom, I need you to stay present. I need you to look at the jurors when they're being questioned. I need you to sit up straight. I need you to react appropriately to what's being said. If the prosecutor says something inflammatory, you can look concerned. If we're making a good point, you can nod slightly. If you just sit there like a statue, like you're not even present, the jurors are going to think you don't care. And if they think you don't care about what happened to the Hartleys, we lose. Do you understand?" Madison looked at him for a long moment, and for the briefest instant, something flickered in her dark eyes. Anger maybe, or resentment, or perhaps just exhaustion at being told how to perform her own humanity. But then it was gone, and her expression returned to neutral, blank, empty. "I'll try," she said quietly. It was the best Lipsky was going to get, and he knew it. "Okay," he said, sighing. "Let's go. Let's go." Santos and Chen came back into the room, and they led Madison down another corridor, through a secure door, and finally into the courtroom itself. The courtroom was large and imposing, a space designed to convey the weight and authority of the law. The ceilings were high, at least 15 feet, lined with recessed lighting that cast everything in a cold, clinical glow. The walls were paneled in dark wood, polished to a shine, and the floor was covered in commercial-grade carpet in a deep burgundy color that muffled footsteps and conversation. At the front of the room, elevated on a platform 3 feet above the floor, sat the judge's bench. A massive structure of dark wood with the seal of the state of Oregon carved into the front panel. Behind it hung the American flag and the Oregon flag, their colors vivid against the wood paneling. To the left of the bench was the witness stand, a smaller wooden structure with a microphone mounted on a flexible arm. To the right was the jury box, 2 rows of 6 chairs each, currently empty, waiting for the 12 citizens who would decide Madison Reeves' fate. The gallery, the seating area for spectators, was divided into rows of wooden benches, like church pews, separated by a narrow aisle down the center. The front rows, closest to the action, were reserved for family members of the victims and the media. Behind them sat true crime enthusiasts who had followed the case obsessively online, members of the public who had won seats in the courtroom lottery, law students from Lewis and Clark and Willamette who wanted to watch a high-profile trial, and a handful of advocates from foster care reform organizations who saw Madison not as a monster but as a symptom of a broken system. The courtroom was packed to capacity. Every seat filled, people standing along the back wall, a palpable tension in the air like the moment before a thunderstorm. In the front rows sat members of the Hartley extended family. Michael Hartley, Robert's older brother, sat in the first row, directly behind the prosecution table. He was 46 years old, a high school history teacher in Beaverton, with sandy brown hair that was graying at the temples and a face that looked like it hadn't smiled in months. He wore a dark suit and a blue tie, Robert's favorite color, and his hands gripped the wooden bench in front of him so tightly his knuckles were white. Beside him sat his wife, Karen, who held a framed photograph of Robert, Susan, Lucas, and Emma. Taken the previous Christmas, just weeks before they would die. In the photo, they were all smiling, gathered around a Christmas tree, Emma holding up a drawing she had made, Lucas grinning at the camera, Robert and Susan with their arms around their children. It was the last family photo they would ever take. Next to Karen sat Patricia Monroe, Susan's younger sister. Patricia was 36, a dental hygienist in Eugene, and she had been devastated by her sister's death. Susan had been her best friend, her confidant, the person she called when life got hard. Now Susan was gone, and Patricia was left with nothing but grief and rage. She wore a black dress and clutched a tissue in her hand, her eyes red and swollen from crying. Behind them sat aunts, uncles, cousins, friends, people whose lives had been touched by the Hartleys, who had come to bear witness to see justice done, to make sure that Madison Reeves paid for what she had done. On the other side of the courtroom, in the back rows, sat a smaller group of people who saw things differently. They were advocates from organizations like Foster Care Reform Oregon, Children First Alliance, and Trauma-Informed Justice Coalition. They held no sign. Judge Torres had forbidden them. But they wore buttons that said context matters and healing over punishment. They believed that Madison was a victim too, that she had been failed by every system meant to protect her, and that locking her up for life wouldn't solve the deeper problems that had created this tragedy. They believed that justice should include accountability, but also compassion, that children who committed terrible acts deserved a chance at redemption, that the foster care system needed to be reformed so that no other child ever fell through the cracks the way Madison had. At the prosecution table sat Ellen Marsh and her team. Marsh was 52 years old, a career prosecutor who had spent her entire professional life in the Multnomah County District Attorney's Office. She had tried over 30 homicide cases in her career and had never lost one where the evidence was this strong. She wore a navy blue suit with a white blouse, minimal jewelry, just a simple gold wedding band and small diamond stud earrings, and her blonde hair was pulled back in a tight bun that accentuated her sharp cheekbones and piercing blue eyes. She sat with perfect posture, her hands folded on top of a stack of color-coded binders that contained every piece of evidence, every witness statement, every legal motion filed in the case. To her left sat Daniel Chen, a 32-year-old assistant prosecutor who specialized in digital forensics and had personally worked with Dr. Alan Cho to extract and analyze Madison's search history. To her right sat Maria Gonzalez, a 50-year-old veteran prosecutor who had tried more arson cases than anyone else in the office and would be handling the testimony of Fire Marshal Derek Coleman. Across the aisle sat the defense team, Lipsky, Parrish, and now Madison herself, escorted into the courtroom by Santos and Chen. The corrections officers removed Madison's ankle shackles. Judge Torres had ruled that she could not be visibly restrained in front of the jury, as it would prejudice them, but left her wrists cuffed under the table, out of view. Madison sat down between Lipsky and Parrish, her movements slow and deliberate, and folded her hands in her lap. She looked small at the defense table, dwarfed by the formality of the space, a teenager in a borrowed blouse, sitting in judgment for acts that would define the rest of her life. She didn't look at the Hartley family members. She didn't look at the prosecution table. She didn't look at anyone. She just stared at her hands and waited. At exactly 10 o'clock, the bailiff, a stocky man in his 50s named Tom Rivera, who had worked courthouse security for 20 years, stood and addressed the courtroom in a booming voice that echoed off the wood-paneled walls. All rise. The Multnomah County Circuit Court is now in session. The Honorable Raymond Torres presiding. Everyone stood. The lawyers, the spectators, the journalists, Madison, and Judge Raymond Torres entered through a door behind the bench. He was 62 years old, a jurist with 25 years on the bench, appointed initially by Governor John Kitzhaber and re-elected twice by comfortable margins. He had silver hair, deep-set brown eyes behind wire-rimmed glasses, and the kind of weathered face that suggested he had seen too much human tragedy to be shocked by any of it. He wore his black robe with quiet authority, and he carried himself with the dignity of someone who understood the weight of his position. He had presided over hundreds of trials: murder, rape, robbery, fraud, domestic violence. But even he had been struck by the brutality of this case when he first reviewed the file. 4 deaths. 2 of them children under the age of 12. A foster child turned murderer. A family that had opened their home to someone in need, only to be burned alive for their kindness. It was the kind of case that stayed with you long after the gavel fell, that haunted your dreams, that made you question whether justice was even possible. "Please be seated," Torres said, his voice calm and measured, the voice of someone who had said those words thousands of times. He settled into his chair, adjusted his glasses, opened the case file in front of him, and scanned the top page briefly before looking up at the crowded courtroom. "Good morning," he said. "We are here today in the matter of State of Oregon versus Madison Reeves, case number 21, TR 147. This is a criminal trial on charges of aggravated murder, arson, and reckless endangerment. Before we begin, I want to remind everyone in this courtroom that you are here as observers, not participants. You will remain silent at all times. You will not react audibly to testimony or evidence. You will not communicate with the jurors. If you cannot abide by these rules, you will be removed. Is that understood?" Murmurs of assent rippled through the gallery. Torres turned to the attorneys. "Counsel, please state your appearances for the record." Ellen Marsh stood, buttoning her jacket as she did so. "Ellen Marsh for the State of Oregon, Your Honor," joined by Assistant Prosecutors Daniel Chen and Maria Gonzalez. Lipsky stood, his hands trembling slightly. "Aaron Lipsky for the defendant Madison Reeves, Your Honor," joined by co-counsel Jennifer Parrish. Torres nodded. "Thank you. Counsel, are we ready to proceed with jury selection?" "Yes, Your Honor," Marsh said. "Yes, Your Honor," Lipsky echoed. "Very well," Torres said. He turned to the bailiff. "Mr. Rivera, please bring in the jury pool." Rivera opened the double doors at the back of the courtroom, and 60 potential jurors filed in, filling the gallery benches behind the Hartley family and the advocates. They were a cross-section of Multnomah County, men and women of various ages, races, and background. Some wore business attire, having come directly from their job. Others wore jeans and sweaters, retirees or freelancers with more flexible schedules. They looked around the courtroom with a mixture of curiosity, apprehension, and civic duty. Most of them had never been called for jury duty on a murder case before. Most of them had no idea what they were about to experience. Judge Torres addressed them, his tone formal but not unkind. "Ladies and gentlemen, thank you for your service. You have been summoned here as potential jurors in a criminal trial. The defendant, Madison Reeves, has been charged with 4 counts of aggravated murder, 1 count of arson in the first degree, and 1 count of reckless endangerment. If you are selected to serve on this jury, you will be required to be here every weekday from 9 a.m. to 5 p.m., with breaks for lunch and occasional recesses. This trial is expected to last approximately 3 weeks. During that time, you will not be allowed to discuss the case with anyone. Not your family, not your friends, not your co-workers. You will not be allowed to read news coverage of the trial or search for information online. Your job is to base your verdict solely on the evidence presented in this courtroom." He paused, letting that sink in. "I want to be clear about the seriousness of this case. 4 people died, 2 adults and 2 children. The evidence you will see and hear may be disturbing. It may be graphic. If you do not believe you can handle testimony about a fatal house fire, about the deaths of children, about forensic evidence and autopsy reports, now is the time to speak up." Several hands went up. Torres called on each person individually, excused those who had legitimate concerns, and thanked them for their honesty. The process we're about to begin is called voir dire, a French term meaning to speak the truth. The attorneys for both sides will ask you questions to determine whether you can be fair and impartial. There are no right or wrong answers. We simply need to know whether you can set aside any biases or preconceptions and judge this case solely on the evidence. Do you understand? The potential jurors nodded. Torres looked at Marsh. "Ms. Marsh, you may begin." Voir dire. Selecting the jury. Ellen Marsh stood and approached the jury pool with a warm but professional smile. She had done this hundreds of times, and she knew how to read people. How to identify who would be sympathetic to the state's case, who would be a problem, who would be a leader in the jury room, and who would simply follow the crowd. She carried a yellow legal pad with notes she had prepared based on the jury questionnaires each potential juror had filled out in advance, and she scanned the faces before her, making mental calculations. "Good morning," she began, her voice clear and confident but not aggressive. "My name is Ellen Marsh, and I'm the prosecutor in this case. I'm going to ask you some questions, and I want you to be completely honest with me. This process only works if we all speak truthfully. So let me start with this. Has anyone here ever been the victim of a crime?" About 15 hands went up. Marsh walked along the rows, making eye contact with each person, asking follow-up questions. "Sir, in the 3rd row, can you tell me what happened?" A man in his 50s cleared his throat. "My car was stolen about 10 years ago. They found it a week later, stripped for parts." "How did that make you feel about the criminal justice system?" "I mean, they never caught the guy, so I wasn't thrilled. But I got insurance money, so it worked out." "Do you think that experience would affect your ability to be fair in this case?" "No, I don't think so." Marsh made a note. This juror was probably fine. Not overly angry at criminals, pragmatic, capable of moving on. She turned to a woman in her 30s who had also raised her hand. "Ma'am, what about you?" "I was mugged when I was in college," the woman said. "Broad daylight, right outside my apartment. Guy held a knife to my throat and took my purse." "I'm so sorry that happened to you," Marsh said, her tone genuine. "Did they catch the person?" "No." "How do you feel about that?" The woman's jaw tightened. "Honestly, I'm still angry. It was 15 years ago, and I'm still angry." Marsh made another note. This juror was potentially useful. Someone who understood victimization and might have strong feelings about accountability. But she might also be too emotional, too personally invested. "Do you think you could set aside those feelings and judge this case fairly?" The woman hesitated. I think so, but I don't know for sure. I appreciate your honesty, Marsh said. She would revisit this juror later. She moved on to her next question. How many of you have children? Most hands went up. And how many of you have ever fostered a child or know someone who has? Only 3 hands went up this time. Marsh focused on them. Ma'am, in the second row. You raised your hand. Can you tell me about your experience? A woman in her 40s spoke up. I was a foster parent for 10 years. My husband and I took in over 20 kids during that time. That's incredibly generous, Marsh said carefully. This was exactly the kind of juror she was worried about. Someone with deep sympathy for foster children. Someone who might see Madison as a victim rather than a perpetrator. Can you tell me about that experience? Was it rewarding? It was the hardest thing I've ever done, the woman said, her voice thick with emotion. These kids have been through hell. Abuse, neglect, abandonment. And the system is broken. Caseworkers are overworked, resources are limited, and kids fall through the cracks all the time. Marsh nodded thoughtfully. I understand. Do you think that experience would make it difficult for you to hold a foster child accountable for a serious crime? The woman paused. I don't know. Maybe. I appreciate your honesty, Marsh said, making a note. She would use a peremptory challenge to remove this juror. Too much sympathy for Madison's background. She continued with more questions, probing for biases, for preconceptions, for anything that might disqualify a juror. She asked about their views on the death penalty. Oregon had abolished it in 2019, but attitudes about punishment still mattered. About whether they believed in rehabilitation or retribution. About whether they could follow the law, even if they disagreed with it. She was meticulous, methodical, and by the end of her questioning, she had a clear picture of who she wanted on the jury and who she wanted gone. When Marsh finished, Judge Torres turned to the defense table. Mr. Lipsky, you may proceed. Aaron Lipsky stood, straightening his jacket, and approached the jury pool. His style was different from Marsh's. Less polished, less commanding, but perhaps more human, more relatable. He didn't have her decades of experience, her trial wins, her confidence. But he had earnestness, and sometimes that counted for something. Good morning, he said, his voice quieter than Marsh's. My name is Aaron Lipsky, and I'm Madison's attorney. I want to thank you all for being here. I know this is an interruption to your lives, and I know this case is difficult. But your service matters. It's one of the most important things you can do as a citizen. He paused, gathering his thought. Let me ask you this. How many of you believe that a person's upbringing, their childhood, their experiences, the trauma they've endured, affects who they become as an adult? Every hand went up. Thank you, Lipsky said. That's important, because this case is about more than just what happened on New Year's Eve. It's about understanding the context. It's about seeing Madison as a whole person, not just as the defendant in a criminal trial. It's about recognizing that children who are abused, neglected, and abandoned often struggle in ways that people from stable homes can't fully understand. Ellen Marsh stood. Objection, Your Honor. Counsel is making an opening statement, not conducting voir dire. Sustained, Torres said, his tone sharp. Mr. Lipsky, please stick to questions. I apologize. Your Honor, Lipsky said, nodding. He turned back to the jury pool. Let me rephrase. How many of you believe that someone can do something terrible and still deserve compassion? About half the hands went up. Lipsky studied the faces of those who didn't raise their hands. These were the people the prosecution would want, the people who believed in punishment over rehabilitation, who saw the world in black and white. For those of you who didn't raise your hands, Lipsky said carefully, can I ask why? And please, I'm not judging. I just want to understand. A man in his 60s spoke up. If you do something terrible, you deserve to be punished. That's just how it works. Do you believe there are ever circumstances that make a person's actions more understandable, even if they're not excusable? The man frowned. Maybe. But murder is murder. I don't care what your childhood was like. Lipsky made a note. This juror would definitely be struck by the defense. He continued his questioning, focusing on empathy, on whether jurors could consider mitigating factors, on whether they understood the difference between explanation and excuse. He was looking for people who were thoughtful, who were willing to wrestle with complexity, who understood that human behavior was not always simple or straightforward. The process took 2 full days. Jury selection was painstaking, exhausting, and fraught with strategic calculations. Marsh and Lipsky each exercised their peremptory challenges, strikes that didn't require a reason, to remove jurors they didn't want. Marsh struck the former foster parent, a social worker, and a therapist who had expressed concerns about punishing teenagers. Lipsky struck the man who believed murder is murder, a retired police officer, and a victim's rights advocate who had lost a family member to a violent crime. By the end of the second day, they had their jury, 12 men and women, plus 2 alternates, who would decide Madison Reeves' fate. The final jury consisted of Euro-1, Sarah Kincaid, 42, a high school English teacher from Southeast Portland, married, 2 teenage children. She had raised her hand when asked about empathy and had said she believed context mattered. Euro-2, David Tran, 35, a software engineer at Intel. Single, no children. He seemed analytical, logical, someone who would focus on the evidence. Euro-3, Margaret Chen, 67, a retired postal worker from North Portland. Widowed, 3 adult children. She had served on a jury once before, a robbery case, and said she believed in following the law. Euro-4, James Rodriguez, 29, a nurse at Providence Portland Medical Center. He worked in pediatrics and had expressed concern about seeing evidence related to children, but ultimately said he could handle it. Euro-5, Linda Patterson, 58, a small business owner who ran a bookstore in Selwood. She had been the victim of a theft years earlier, but said it wouldn't affect her judgment. Euro-6, Kevin Oladipo, 44, a stay-at-home father of 3 young children. He had been a defense attorney before leaving the practice to care for his kids, and both sides had questioned him extensively about whether he could be impartial. He assured them he could. Euro-7, Amanda Fisher, 31st, a graphic designer who worked freelance from home. She was soft-spoken, thoughtful, and said she believed in rehabilitation. Euro-8, Robert Hayes, 52, an accountant at a downtown firm. He was methodical, detail-oriented, and said he liked having clear facts. Euro-9, Teresa Martinez, 36, an auto mechanic who owned her own shop. She had never served on a jury before and said she was nervous but willing to do her duty. Euro-10, Christopher Lane, 27, a barista at a coffee shop in the Pearl District. He was young, idealistic, and said he believed people could change. Euro-11, Patricia Sullivan, 63, a librarian at the Multnomah County Library System. She was well-read, thoughtful, and said she valued evidence and facts. Euro-12, Marcus Washington, 48, a real estate agent who had lived in Portland his entire life. He was pragmatic, no nonsense, and said he would follow the law. These 12 people would now hear the evidence, deliberate, and decide whether Madison Reeves was guilty of murdering the Hartley family. Opening statements. On the morning of October 18, 2021, the trial began in earnest. The jury filed into the courtroom at 9:30 and took their seats in the jury box. They looked nervous, uncertain, aware of the weight of what they were about to undertake. Judge Torres addressed them once more, explaining the structure of the trial, the burden of proof, the presumption of innocence. He spoke for nearly 20 minutes, his voice steady and authoritative, and the jurors listened with the solemn attention of people who understood the gravity of their role. "Members of the jury," Torres said, "you are about to hear evidence in a criminal trial. It is your job, and yours alone, to determine the facts of this case. I will instruct you on the law, but you must apply that law to the facts as you find them. You must base your verdict solely on the evidence presented in this courtroom. You cannot conduct your own research. You cannot Google the case or read news articles. You cannot discuss the case with anyone outside the jury room." He paused, looking at each juror in turn, making sure they understood. In a criminal case, the burden of proof is on the prosecution. The defendant is presumed innocent unless and until the state proves her guilt beyond a reasonable doubt. That is a high standard, the highest in our legal system. Beyond a reasonable doubt does not mean beyond all possible doubt. But it does mean that you must be firmly convinced of the defendant's guilt before you return a guilty verdict. If, after he turned to the prosecution table, "Ms. Marsh, you may present your opening statement." Ellen Marsh stood, buttoned her navy jacket, and approached the jury box. She carried a single note card, but she barely glanced at it. She had delivered opening statements in over 30 murder trials, and she knew exactly what she wanted to say. She stood in front of the jury box for a long moment, making eye contact with each juror, letting the silence build, letting them feel the weight of this moment. "Ladies and gentlemen," she began, her voice clear and steady, "this is a case about betrayal. It's about premeditation, and it's about murder." She let those words hang in the air before continuing. On New Year's Eve 2020, the Hartley family gathered in their home in the Eastmoreland neighborhood of Portland to celebrate the end of a difficult year and the beginning of a new one. It had been a hard year for everyone. COVID-19 had upended our lives, forced us into isolation, made us confront uncertainty and fear in ways we never had before. But the Hartleys were determined to find joy where they could. They decorated their home with lights and garlands. They prepared a feast, appetizers, fondue, desserts. They made plans to stay up until midnight to watch the ball drop in Times Square and welcome 2021 with hope. Marsh walked slowly along the jury box, her tone measured, her words deliberate. Robert Hartley, 42 years old, was a senior software engineer at Intel. He had worked there for 15 years, was respected by his colleagues, and loved solving complex problems. But his real passion was his family. He loved taking his kids hiking in the gorge, teaching them about technology, playing video games with his son Lucas. He was a good man, a devoted father, someone who believed in... She paused, her expression softening. Susan Hartley, 40 years old, was a pediatric nurse at Oregon Health and Science University. She spent her days caring for sick children, comforting frightened parents, advocating for her patients. She worked long shifts, often came home exhausted, but she never complained. She loved her job, she loved her family. And when she heard about Madison Reeves, a teenager in foster care who needed a stable home, Marsh turned slightly, gesturing toward the gallery where the Hartley family members sat. Lucas Hartley was 11 years old. He loved science fiction, loved video games, loved spending time with his friends. He was smart, curious, and kind. Emma Hartley was 8 years old. She loved to draw, loved to read, loved making things with her hands. She made paper chains to decorate the house for New Year's Eve. She drew pictures of her family and hung them on the refrigerator. Marsh's voice grew quieter, more somber. They were a good family, a loving family. And they had opened their home to Madison Reeves, a 17-year-old girl who had spent years in foster care, who had been abandoned by her biological mother, who needed stability and support. The Hartleys didn't have to take Madison in. They could have said no. They already had 2 children of their own, busy careers, full lives. But they didn't say no. They said yes. They gave Madison a bedroom. They gave her meals. They gave her a place to belong. They treated her like family. Non for Shamar. Marsh turned to look at Madison, who sat expressionless at the defense table, her hands folded in her lap, her eyes down. And Madison Reeves repaid that kindness by murdering them. A murmur rippled through the courtroom. Judge Torres's gaze sharpened, but he said nothing. This was Marsh's opening, and she was allowed to be forceful. Marsh turned back to the jury, her voice hardening. The evidence in this case will show that Madison Reeves spent 6 weeks planning this crime. She didn't wake up on New Year's Eve and make a rash decision. She didn't act in a moment of anger or desperation. She planned. She researched. She prepared. She executed her plan with chilling precision. Marsh walked to the prosecution table and picked up a large exhibit. A blown-up screenshot of Madison's Google search history mounted on foam board. She carried it to the jury box and held it up so they could all see it clearly. "You will see searches like these," she said. "How to start a fire in a house. How fast does house fire spread? Smoke inhalation death versus burning. Do smoke detectors go off immediately? How to disable smoke detector without anyone noticing. House fire investigation techniques. Accidental house fire versus arson. Candle fire statistics. How?" She let the jury absorb the words, watching their faces. Several jurors looked disturbed. Good. Good will hear. Madison Reeves researched how to commit this crime and how to get away with it. Marsh continued. She wanted it to look like an accident. And she chose New Year's Eve because house fires are statistically common on holidays. Fires caused by candles, by fireworks, by careless cooking. She thought no one would suspect her. She thought she could get away with it. Marsh set the exhibit down on the ledge of the jury box and picked up another. A photograph of 2 red gas cans sitting on a concrete floor. On December 23, 2020, 8 days before the fire, Madison Reeves walked to a Fred Meyer store on Hawthorne Boulevard. She purchased these 2 gas cans. She paid cash, $47.89. She wore a black hoodie with the hood pulled up, avoiding security cameras. After leaving Fred Meyer, she walked 6 blocks to a Shell gas station and filled both cans with premium unleaded gasoline. Over 10 gallons in total. She paid cash again, $38.50. Then she carried those cans, which now weighed over 60 pounds combined, back to the Hartley home, a distance of over 2 miles, and she hid them in her bedroom closet. Marsh placed the photograph on the jury box ledge next to the search history. For 8 days, Madison Reeves lived in that house with those gas cans hidden in her closet. She ate meals with the Hartley family. She watched TV with them. She pretended everything was normal, and all the while, she was planning to kill them. Marsh walked back toward the center of the courtroom, her voice growing stronger. On the night of December 31st, the Hartleys celebrated. They had dinner together. They played games. They watched the New Year's Eve special on TV. And at around 8:15 p.m., Madison told them she was tired and went upstairs to bed. Marsh paused for effect, but she didn't go to bed. She went to her closet. She retrieved the gas cans, and she began to pour. Marsh's voice dropped, becoming almost a whisper, forcing the jurors to lean forward to hear her. She poured gasoline in the hallway outside her bedroom. She poured it in Lucas's room. She poured it in Emma's room. She poured it in Robert and Susan's room. She poured it on the carpet, on the furniture, on the walls. She used over 7 gallons of accelerant. And then, at approximately 11:50 p.m., just 10 minutes before midnight, she lit a match. Marsh's voice rose again, filling the courtroom. The fire spread instantly. Gasoline burns hot and fast. Over 1,000 degrees Fahrenheit. Within seconds, the entire second floor was engulfed in flames. Smoke filled the house. The fire alarm went off. And downstairs, Robert and Susan Hartley smelled the smoke and heard the alarm and realized something was terribly wrong. Marsh's expression grew pained, as if she herself could feel the horror of that moment. Robert ran toward the stairs. He tried to get to his children, but the heat was unbearable. The flames were already consuming the staircase. He couldn't get through. Susan screamed for Lucas and Emma, but they couldn't hear her over the roar of the fire. Lucas died in his bedroom from smoke inhalation. He never woke up. Emma died in the bathroom, where she had tried to hide. She was terrified, alone, and she couldn't breathe. Robert and Susan died together at the base of the stairs, trying one last time to reach their children. Near dear. Several jurors looked visibly shaken. One woman pressed a tissue to her eyes. And where was Madison Reeves? Marsh asked, her voice hard now, cold. She climbed out her bedroom window. She jumped to the ground, and she walked away. Marsh walked over to the evidence table and picked up another photograph. A still image from surveillance footage showing Madison in a convenience store. This photograph was taken at 12:05 a.m. on January 1, 2021, 18 minutes after the fire started. Madison Reeves is standing at the counter of a 7-Eleven 3 blocks from the Hartley home. She is buying a bottle of water, a pack of gum, and a prepaid phone card. Look at her face. Marsh held the photo up so the jury could see it clearly. Madison's expression in the photo was calm, neutral, unremarkable. She's not panicked. She's not crying. She's not distraught. She looks like someone buying snacks on a normal night. Because to her, this was a normal night. She had executed her plan. She had gotten away. And 4 people were dead. Marsh set the photo down and returned to the jury box, leaning slightly forward, her voice intense. The defense will tell you that Madison Reeves is a victim, that she was traumatized by her childhood, that she was failed by the foster care system. And some of that is true. Madison did have a difficult childhood. She was abandoned by her mother. She did move between foster homes. But millions of children experience trauma, and they don't murder innocent people. Trauma is not an excuse. It's not. Marsh straightened, her tone becoming more formal. The law is clear. To prove aggravated murder, the state must show 3 things. First, that the defendant caused the death of another human being. Second, that she did so intentionally. And third, that she did so with premeditation. Meaning, she planned it in advance. The evidence in this case will prove all 3 elements beyond any reasonable doubt. Marsh walked back to the prosecution table, picked up a thick binder, and held it up. You will hear from Detective Carla Winters, who investigated this case and arrested Madison Reeves. You will hear from Fire Marshal Derek Coleman, who determined that this fire was arson and that gasoline was used as an accelerant. You will hear from Dr. Alan Cho, a digital forensics expert, who will walk you through Madison's search history and show you the unsent text message she wrote to her mother, a message that is essentially a confession. You will hear from the medical examiner, Dr. Patricia Green, who will tell you how each victim died and how much they suffered. And you will see surveillance footage, photographs, forensic reports, and physical evidence that all point to one inescapable conclusion. Madison Reeves planned this crime, executed it, and then tried to flee. Marsh set the binder down and faced the jury one last time. 4 people are dead. Robert Hartley, who tried to save his children and died trying. Susan Hartley, who spent her life caring for others and died trying to protect her own. Lucas Hartley, an 11-year-old boy who died terrified in his bedroom. Emma Hartley, an 8-year-old girl who died hiding in a bathroom, alone and afraid. Marsh's voice grew quieter, more solemn. At the end of this trial, after you have heard all the evidence, I will ask you to return guilty verdicts on all counts. I will ask you to hold Madison Reeves accountable for what she did. Because that is what the evidence demands. Because that is what the evidence demands. Because that is what justice requires. Because Robert, Susan, Lucas, and Emma deserve nothing less. Thank you. She returned to her seat. The courtroom was utterly silent except for the quiet sound of someone crying in the gallery. Patricia Monroe, Susan's sister, her face buried in her hands. Judge Torres waited a respectful moment before turning to the defense table. Mr. Lipsky, your opening statement. Aaron Lipsky stood slowly. His hands were trembling. He could feel them shaking as he buttoned his jacket, and he clasped them together briefly to steady himself. He had practiced this opening a dozen times, had rewritten it over and over, trying to find the right tone, the right words, the right way to make the jury see Madison as something other than a monster. He walked toward the jury box, and for a moment he just stood there, looking at them, his expression pained. "Ladies and gentlemen of the jury," he began, his voice soft, almost hesitant, "I want to start by acknowledging the tragedy of what happened on New Year's Eve. 4 people died. A family was destroyed. Children lost their lives. And nothing I say here, nothing I do in this trial, will change that. Nothing will bring Robert, Susan, Lucas, and Emma Hartley back. Their deaths are a tragedy that cannot be undone." He paused, his throat tight with emotion. "But I want you to understand something about Madison Reeves. She is not a monster. She is not evil. She is a child, a deeply traumatized, deeply damaged child who was failed by every system that was supposed to protect her." Lipsky walked toward the jury, his movements slow, deliberate. Madison was born into chaos. Her mother, Brenda Reeves, was a 22-year-old waitress with a substance abuse problem and a series of unstable relationships. Madison's father was never identified. Brenda didn't know which of 3 men it could have been. From the moment Madison was born, her life was precarious. Lipsky's voice grew more passionate. By the time Madison was 7 years old, Child Protective Services had been called to her home multiple times. There were reports of neglect, of Brenda leaving Madison alone for hours, of spoiled food and filthy living conditions. And each time, CPs would Madison would be. He gestured toward Madison, who sat motionless at the defense table. When Madison was 11 years old, 11, her mother abandoned her. Brenda Reeves got into a car with her boyfriend and drove to California. She left Madison alone in their apartment. No food, no money, no way to take care of herself. Madison was found 3 days later by a teacher who noticed she was wearing the same clothes to school and hadn't bathed. Lipsky's voice cracked slightly. Imagine that. Imagine being 11 years old and waking up one day to find that your mother, the person who is supposed to love you unconditionally, the person who is supposed to keep you safe, has abandoned you, just walked away, and never looked back. He paused, letting that image settle over the jury. Madison became a ward of the state, and for the next 6 years she was moved from foster home to foster home, group home to group home. She never stayed anywhere long enough to feel safe. She never had a consistent therapist. She never had a stable adult figure in her life. She was treated like a problem to be managed, not a person to be helped. And with each move, with each new home, she became more withdrawn, more damaged, more convinced that no one would ever truly care about her. Lipsky turned to face the prosecution table briefly before looking back at the jury. The prosecution wants you to believe that Madison is a cold-blooded killer who planned a murder for 6 weeks and executed it without remorse. But what you're going to see is a girl who was desperate, who was drowning in trauma, who didn't know how to ask for help. Yes, a fire started. Yes, people died. But this was not a calculated, premeditated murder. This was a tragedy born of neglect. His voice grew stronger, more impassioned. The foster care system in this country is broken. Kids like Madison are passed around like packages, moved from home to home, never given a chance to heal. Caseworkers are overworked. Some carry caseloads of 50, 60, even 70 children. There aren't enough resources, not enough therapists, not enough support. And when something terrible happens, when a child like Madison reaches a breaking point, we don't ask. Lipsky walked back toward the defense table, his tone becoming more pleading. I'm not asking you to excuse what happened. I'm not asking you to say it was okay. But I am asking you to understand the context. I'm asking you to see Madison as a whole person, not just as the defendant in a criminal trial, but as someone who has endured unimaginable pain and loss. I'm asking you to consider that sometimes people do terrible things, not because they're evil, but because... He turned back to the jury. The law recognizes different levels of culpability. It recognizes that not all killings are the same. Aggravated murder requires premeditation, a deliberate, calculated plan to kill. But the evidence will show that Madison was not thinking clearly, that she was in a state of emotional crisis, that she lacked the capacity to fully understand the consequences of her action. Lipsky's voice dropped. You will hear from Dr. Helen Morris, a clinical psychologist who evaluated Madison. She will tell you about complex PTSD, about attachment disorder, about how years of abandonment and instability can fundamentally change the way a person's brain works. Madison was not a calculating killer. She was a traumatized child who reached a breaking point. No. He paused, his expression earnest. At the end of this trial, I will ask you to find Madison not guilty of aggravated murder. I will ask you to recognize that while a terrible tragedy occurred, it was not the product of premeditation and intent. I will ask you to see Madison as a human being who deserves compassion, not as a monster who deserves to be locked away forever. Lipsky returned to his seat, his shoulders sagging with the weight of what he had just said. Judge Torres looked at the clock. It was nearly noon. We'll break for lunch. We'll reconvene at 1:30, at which time the prosecution may call its first witness. The bailiff stood. All rise. Everyone stood as Judge Torres exited through the door behind the bench. The moment he was gone, the courtroom erupted in murmurs. Journalists scribbled notes. Family members wiped their eyes. And Madison sat motionless at the defense table, her face betraying nothing, as if she hadn't heard a word of what had just been said about her. The prosecution's case, Week 1. After the lunch recess, the courtroom reconvened at 1:30. The jury filed back in, their faces still reflecting the weight of the opening statements they had just heard. Some looked at Madison with curiosity, others with barely concealed hostility. Madison herself sat at the defense table with the same blank expression she had worn all morning, her hands folded in her lap, her eyes fixed on nothing in particular. Judge Torres settled into his chair and addressed the courtroom. We will now begin with the presentation of evidence. Ms. Marsh, you may call your first witness. Ellen Marsh stood, smoothed her jacket, and approached the bench. The state calls Detective Carla Winters, Your Honor. The bailiff opened the door at the side of the courtroom, and Detective Carla Winters entered. She was 41 years old, with short cropped brown hair streaked with gray at the temples, sharp green eyes that missed nothing, and the bearing of someone who had spent 15 years investigating the worst things human beings could do to each other. She wore a charcoal gray pantsuit with a white blouse, low black heels, and minimal jewelry, just a simple watch and small silver earring. She walked to the witness stand with confidence, placed her left hand on the Bible, raised her right hand, and swore to tell the truth. Please state your name and occupation for the record, Marsh began. Carla Winters. I'm a detective with the Portland Police Bureau, Major Crimes Unit. How long have you been a detective? Detective Winters. 15 years. And during those 15 years, approximately how many homicide investigations have you conducted? I've been the lead or co-lead investigator on 43 homicide cases. Thank you. Detective Winters, were you the lead investigator in the case involving the deaths of Robert, Susan, Lucas, and Emma Hartley? Yes, I was. Can you tell the jury how you became involved in this investigation? Winters turned slightly toward the jury, making eye contact with several jurors as she spoke, a technique she had learned early in her career to help jurors connect with her testimony. On December 31, 2020, at approximately 1:10 a.m., I received a call from my supervisor, Lieutenant Mark Dawson, informing me that there had been a fatal house fire in the Eastmoreland neighborhood and that I was being assigned as the lead investigator. I immediately got dressed, drove to the scene, and arrived at approximately 1:35 a.m. What did you observe when you arrived? The residence at 4427 Southeast Eastmoreland Drive was fully engulfed in flames. Portland Fire and Rescue were still actively fighting the fire. There were multiple engine companies on scene, ladder trucks, and the fire was so intense that flames were visible through the roof. The heat was extraordinary. I could feel it from the street. What did you do next? I spoke with Battalion Chief Raymond Torres, who was the incident commander on scene. He informed me that the homeowners, Robert and Susan Hartley, had 2 biological children, Lucas, age 11, and Emma, age 8, and 1 foster child, Madison Reeves, age 17. He said that Robert and Susan had been transported to the hospital with critical injuries and were not expected to survive. He believed the children. Winters' jaw tightened slightly. I immediately began coordinating with fire and rescue to determine when it would be safe to enter the structure and begin the investigation. I also asked the battalion chief if all family members were accounted for. He told me that Robert, Susan, and their daughter Emma had been outside when first responders arrived, but that Lucas and Madison were missing. Marsh walked to the evidence table and picked up a large foam board with a photograph mounted on it. The Hartley home, photographed from the street, on the morning of January 1st, after the fire had been extinguished. The structure was a blackened skeleton. The roof collapsed, the windows blown out, smoke still rising from the debris. Detective Winters, I'm showing you what's been marked as State's Exhibit 1. Do you recognize this photograph? Winters looked at it. Yes. This is the Hartley residence as it appeared on the morning of January 1st, 2021, after the fire was extinguished. Can you describe what we're seeing? The structure sustained catastrophic damage. The roof has completely collapsed. The second floor, where the bedrooms were located, is almost entirely destroyed. You can see that the exterior walls are heavily damaged, and in some places you can see straight through to what's left of the interior. The windows have all been blown out by the heat. The fire was most intense on the second floor, which is consistent with the fire marshal's. Marsh placed the photograph on an easel so the jury could continue to see it throughout the testimony. Detective Winters, at what point were you able to enter the residence? At approximately 7:15 a.m. on January 1st, Fire Marshal Derek Coleman cleared the structure as safe to enter, though we still had to be extremely careful because of structural instability. I entered with Fire Marshal Coleman, 2 fire investigators, and a forensic photographer from our crime lab. What did you find? Winters' expression grew somber. We found 4 bodies. The courtroom was silent, even though everyone knew this was coming. It was in the charging documents. It had been in the news for months. Hearing a detective say it out loud, in the formal setting of a courtroom, made it real in a way that news reports never could. Can you tell the jury where the victims were found and identify them? Yes. The first victim we located was Lucas Hartley, age 11. He was found in his bedroom on the second floor. In his bed, he appeared to have died in his sleep from smoke inhalation. The second victim was Emma Hartley, age 8. She was found in the upstairs bathroom, partially behind the toilet. It appeared she had been trying to hide or had gone there thinking she would be safe from the smoke. The third and fourth victims were Robert and Susan Hartley. They were found together at the base of the staircase that led from the first floor to the second floor. They appeared to have been attempting to reach the second floor when they were overcome by smoke and heat. No. Several jurors looked visibly shaken. Juror #4, James Rodriguez, the pediatric nurse, closed his eyes briefly and took a deep breath. Detective Winters, based on where the bodies were found, what conclusions did you draw about what happened? Lipsky stood. Objection, Your Honor. Speculation. Your Honor, Marsh countered. Detective Winters is an experienced investigator with 15 years of homicide experience. She's qualified to offer an opinion based on the physical evidence. I'll allow it, Torres said. You may answer, Detective. Winters continued. Based on the locations of the bodies and the physical evidence at the scene, it appeared that Robert and Susan Hartley became aware of the fire, likely from smoke alarms and the smell of smoke, and attempted to reach their children on the second floor. However, the staircase was already fully engulfed in flames by that point, and the heat would have been unbearable. They made multiple attempts, as evidenced by burn patterns on the walls near. Marsh let that testimony sit for a moment before continuing. Detective Winters, you mentioned that there were 5 family members: Robert, Susan, Lucas, Emma, and Madison Reeves. You've accounted for 4 of them. What about Madison? Madison was not found in the house. What did you do when you realized she was missing? I immediately issued a BOLO, a Be on the Lookout alert, describing Madison Reeves and listing her as a person of interest in a fatal house fire. The BOLO went out to all law enforcement agencies in Oregon and neighboring states. I also requested that our dispatch center contact the FBI in case Madison had fled across state lines. Did you suspect at that point that Madison might have been involved in starting the fire? I had questions. In my experience, when there's a fatal house fire and one family member is unaccounted for, that person is either a victim who hasn't been found yet, or they're a suspect. Given that we had thoroughly searched the residence and Madison was definitely not inside, I needed to locate her as quickly as possible. When did you locate Madison Reeves? At approximately 6:37 a.m. on January 1st, we received a call on our tip line from a woman who said she had seen Madison at the Greyhound bus station in downtown Portland. I responded to that location with 4 uniformed officers, and we found Madison sitting on a bench near the ticket counter. What was Madison doing when you found her? She was sitting alone, wearing a black hoodie and jeans with a backpack at her feet. She appeared to be waiting for a bus. What was her demeanor? She was calm, not visibly distressed. When I approached her and identified myself as a police officer, she looked up at me but didn't say anything. What did you say to her? I asked her to confirm her identity. She said, "I'm Madison Reeves." I then told her that there had been a fire at the Hartley residence and that 4 people were dead. I asked her where she had been. She said she didn't want to talk without a lawyer. How did she react when you told her that 4 people were dead? Lipsky stood. Objection. Calls for speculation and interpretation. Your Honor, Marsh said, I'm asking the detective to describe what she observed, not to interpret Madison's thoughts. Overruled. You may answer, Detective. She showed no visible emotion, Winters said. No tears, no shock, no distress. She just stared at me. What happened next? I placed her under arrest for 4 counts of murder and 1 count of arson. I read her Miranda rights, cuffed her, and transported her to the Multnomah County Detention Center for booking. Did she say anything during the transport? No. She remained silent the entire time. Marsh walked back to the evidence table and picked up a clear plastic evidence bag containing a cell phone. Detective Winters, I'm showing you what's been marked as State's Exhibit 7. Do you recognize this item? Yes. That's an iPhone that was recovered from Madison Reeves' bedroom at the Hartley residence. Where specifically was it found? It was on the nightstand next to her bed. Was the phone damaged by the fire? No. Madison's bedroom sustained significantly less fire damage than the rest of the second floor. The door had been closed, which protected the room somewhat. The phone was intact and functional. What did you do with this phone? I obtained a search warrant and sent it to our digital forensics unit for analysis. We'll hear more about what was found on that phone from another witness. Detective Winters, let me ask you. In your 15 years as a homicide detective, have you ever investigated a case where a house fire was used to commit murder? Yes. 3 times. And in those cases, were you able to determine whether the fires were accidental or intentional? In all 3 cases, fire investigators determined the fires were arson. Thank you, Detective. No further questions. Marsh returned to her seat, and Judge Torres turned to the defense table. Mr. Lipsky, your witness. Aaron Lipsky stood and approached the witness stand. He knew that cross-examining Carla Winters would be difficult. She was experienced, composed, and sympathetic. But he had to try to undermine her testimony, to create doubt, to humanize Madison. Good afternoon, Detective Winters. Good afternoon. You testified that Madison was calm when you arrested her at the bus station. Is it possible that she was in shock? It's possible. In your experience as a detective, have you encountered people who react to traumatic events with emotional numbness or dissociation? Yes, I have. So it's not unusual for someone who has experienced trauma to appear calm or emotionally flat. It's not unusual, no. You also testified that Madison invoked her right to counsel immediately. She didn't try to talk her way out of the situation, didn't make excuses, didn't try to flee when you approached her. She just asked for a lawyer, which is her constitutional right. Correct? Correct? Correct. Dot. And you didn't find any physical evidence on Madison's person that directly linked her to starting the fire, did you? No matches, no lighter, no gasoline residue on her clothing? We did not find those items on her person at the time of arrest. No. Detective Winters, when you entered Madison's bedroom at the Hartley residence, you noted that it sustained less fire damage than other parts of the house. Was the door closed or open? The door was closed. And is it unusual for someone to close their bedroom door before going to sleep? No, it's not unusual. So the fact that Madison's bedroom door was closed doesn't necessarily indicate she was trying to protect evidence, does it? Winters paused. It's consistent with both innocent behavior and an attempt to protect the room from fire damage. Thank you. No further questions. Lipsky returned to his seat, and Judge Torres looked at Marsh. Redirect. Briefly, Your Honor. Marsh stood. Detective Winters, Mr. Lipsky asked whether Madison appeared to be in shock when you arrested her. You testified that it's possible, but you also observed her in the hours after her arrest, correct? What? Yes. I interviewed her approximately 3 hours after her arrest. And what was her demeanor during that interview? The same. Calm, emotionally flat, uncooperative. She refused to answer any questions. Did she at any point ask about the Hartley family? Ask if anyone had survived? Express any concern or remorse? No. She said nothing except that she wanted a lawyer. Thank you. Nothing further. Torres looked at the clock. We'll take a 15-minute recess. When court resumed, Ellen Marsh called her second witness. The state calls Fire Marshal Derek Coleman. Derek Coleman was a man in his late 40s with a weathered face, close-cropped gray hair, and the build of someone who had spent decades doing physical work. He wore his dress uniform, a dark blue suit with a badge and patches identifying him as a fire marshal with Portland Fire and Rescue. He had investigated over 200 fires during his 20-year career, and he had testified in court dozens of times. He took the stand, was sworn in, and settled into the witness chair with the ease of someone who knew exactly what was coming. Please state your name and occupation for the record, Marsh began. Derek Coleman. I'm a fire marshal with Portland Fire and Rescue, assigned to the Arson investigation unit. How long have you been a fire marshal? 20 years. And during that time, approximately how many fires have you investigated? Over 200? Marshal Coleman, were you assigned to investigate the fire at the Hartley residence on December 31st, 2020? Yes, I was. I was called to the scene at approximately 2 a.m. and arrived shortly thereafter. Can you describe what you observed when you arrived? The structure was fully involved. That means the fire had spread throughout the entire house and was burning intensely. Multiple engine companies were fighting the fire, but it was clear that the structure was going to be a total loss. My job at that point was to coordinate with the incident commander and prepare to conduct an origin and cause investigation once the fire was extinguished and it was safe to enter. When were you able to enter the structure? At approximately 7 a.m. on January 1st, after the fire had been completely extinguished and we had assessed the structural stability. What did you do once you entered? I began my investigation by examining the burn patterns, the areas of most severe damage, and the overall fire progression. In arson investigation, we work backwards. We look at where the fire caused the most damage and trace it back to determine where it started and what caused it. Marsh walked to the evidence table and retrieved a series of large photographs mounted on foam boards. She carried them to an easel and began displaying them one by one as Coleman testified. Marshal Coleman, I'm showing you what have been marked as State's Exhibits 8 through 15. Do you recognize these photographs? Coleman looked at them. Yes. These are photographs I took during my investigation of the second floor of the Hartley residence. Can you walk the jury through what these photographs show? Coleman stood and approached the easel. He pointed to the first photograph, which showed a charred hallway with blackened walls and floor. This is the hallway on the second floor, looking from the staircase toward the bedrooms. As you can see, the damage here is severe. The carpet is completely burned through in places, and you can see the underlying floorboards. The walls are charred, and in some areas, the drywall has burned away completely, exposing the studs. He pointed to a specific area of the photograph where the burn damage was particularly deep. These darker, more intense burn patterns here are what we call pour patterns. They indicate that a liquid accelerant, in this case, gasoline, was poured on the floor and then ignited. Accelerants burn hotter and faster than normal combustibles, like wood or carpet, and they leave distinctive patterns. Marsh nodded. How can you tell it was gasoline specifically? We took samples of the carpet and flooring from multiple locations and sent them to the state crime lab for analysis. The lab confirmed the presence of gasoline. Coleman moved to the next photograph, which showed a bedroom. Lucas's room. This is one of the children's bedrooms. Again, you can see pour patterns on the floor near the doorway, and there's evidence of accelerant use on the bed frame and dresser. He moved to another photograph. Emma's room. Same thing here. Pour patterns, accelerant detected in lab analysis. Finally, he pointed to a photograph of the master bedroom. And here, in the master bedroom, we found the most extensive use of accelerant. The pour patterns indicate that gasoline was poured on the bed, the curtains, and the floor. Marsh let the jury absorb the photographs before asking her next question. Marshal Coleman, based on your investigation, did you determine the origin and cause of this fire? Yes. The fire originated on the second floor of the residence, in the hallway outside the bedrooms. The cause was arson, specifically the intentional ignition of a liquid accelerant, gasoline. In your expert opinion, is there any possibility that this fire was accidental? Coleman shook his head firmly. No. There is absolutely no possibility that this fire was accidental. Accidental fires typically have a single point of origin and spread outward from that point. This fire had multiple ignition points, indicating that accelerant was poured throughout the second floor and then ignited. That is the hallmark of arson. Thank you, Marshal Coleman. Can you also tell the jury about the items you recovered from one of the bedrooms? Yes, in the bedroom at the end of the hall, which we later learned was Madison Reeves' room. We found 2 empty 5-gallon gas cans in the closet. They were red plastic containers, the kind you can buy at any hardware or automotive store. We tested them for residue, and both tested positive for gasoline. Marsh walked to the evidence table and retrieved 2 red gas cans sealed in large clear plastic bags. She carried them to the witness stand. Marshal Coleman, are these the gas cans you recovered? Yes, they are. And where exactly were they found? They were in the closet of Madison Reeves' bedroom, hidden beneath a pile of clothing and behind several cardboard boxes. Did you find it significant that they were hidden? Yes. If these gas cans had been stored in a garage or shed, somewhere you'd normally keep gasoline, it wouldn't be unusual. But finding them hidden in a bedroom closet suggests they were being concealed deliberately. Thank you, Marshal Coleman. No further questions. Lipsky approached for cross-examination. Marshal Coleman, you testified that you found 2 empty gas cans in Madison's closet, correct? Correct. Bet. But you didn't actually see Madison purchase those gas cans, did you? No. I did not personally witness the purchase. And you didn't see her fill them with gasoline? No. And you didn't see her pour gasoline on the second floor or light the fire? No. I'm a fire investigator, not a witness to the crime. So your testimony is based entirely on physical evidence and forensic analysis, not eyewitness observation. That's correct. Marshal Coleman, is it possible that someone other than Madison Reeves could have purchased those gas cans, brought them into the house, and started the fire? Coleman paused. It's theoretically possible, but... Thank you. No further questions. Marsh stood. Redirect, Your Honor. Marshal Coleman, Mr. Lipsky, asked whether someone other than Madison could have started the fire. Let me ask you this. The gas cans were found in Madison's bedroom, correct? Correct. And Madison's bedroom was at the end of the hall, the farthest from the staircase. Yes. No. So if someone other than Madison had started this fire, they would have had to enter the house, go upstairs, pour gasoline throughout the second floor, light the fire, and then somehow escape, all without being noticed by any of the family members who were home at the time? That's correct. Does that seem likely to you? No, it does not. Thank you. Nothing further. Judge Torres looked at the clock. It was nearly 4:30. We'll adjourn for the day. Jurors, please remember my instructions. Do not discuss this case with anyone. Do not read news coverage. Do not conduct your own research. We'll reconvene tomorrow at 9 a.m. The bailiff stood. All rise. The prosecution's case. Week 2. Over the next several days, Ellen Marsh methodically built her case, witness by witness, exhibit by exhibit. On day 3, she called Dr. Alan Cho, a digital forensics expert with the Oregon State Police. Dr. Cho was in his early 40s, with black hair, wire-rimmed glasses, and the precise manner of someone who spent his days analyzing data. Data. He took the stand and explained how he had extracted data from Madison's iPhone, iPad, and laptop. Dr. Cho, Marsh asked, can you tell the jury what you found in Madison Reeves' search history? Yes, I found a pattern of searches beginning in mid-November 2020 and continuing through late December 2020 that indicated the user was researching how to commit arson and avoid detection. Marsh displayed the searches on a large screen for the jury to see. November 14, 2020, 10:47 p.m. How to start a fire in a house. November 14, 2020, 10:51 p.m. Accelerants for fire. November 14, 2020, 10:54 p.m. Can arson investigators tell if fire was set on purpose? November 18, 2020, 11:32 p.m. How fast does house fire spread? November 18, 2020, 11:40 p.m. Smoke inhalation death versus burning. November 22, 2020, 9:15 p.m. Do smoke detectors go off immediately? November 22, 2020, 9:18 p.m. How to disable smoke detector without anyone noticing. December 3, 2020, 1:14 a.m. Life insurance payout for foster parents. December 10, 2020, 10:05 p.m. House fire investigation. How long? December 15, 2020, 11:50 p.m. New Year's Eve house fires. December 20th, 2020, 3:34 p.m. Fred Meyer gas can. The jury stared at the screen, their faces reflecting shock and disgust. Several jurors were taking notes. Dr. Cho, Marsh asked, in your expert opinion, what does this search history indicate? It indicates premeditation. The user was researching how to commit arson over a period of approximately 6 weeks. The searches became more specific over time, suggesting the user was planning an actual crime, not just expressing casual curiosity. Did you find anything else on Madison's devices? Yes, I found an unsent draft text message in her iPhone's messaging app. Marsh displayed the text message on the screen. You abandoned me when I was 11. You chose drugs and some loser boyfriend over your own daughter. I was thrown into foster care and passed around like trash for 6 years. Now I'm with the perfect family. The Hartleys, who pretend to care but really just want to feel good about themselves. You want to know what I've learned? People are selfish. Everyone uses everyone. And I'm done being used. Tonight, I take back control. Tonight, they learn what happens when you treat people like they're disposable. No. By the time you read this, it'll be all over the news. Maybe then he'll finally notice I exist. Maybe then you'll regret what you did. Or maybe you won't care at all. Either way, it doesn't matter anymore. I'll finally be someone you can't ignore. Madison. The courtroom was silent as the jury read the message. Several jurors looked at Madison, who sat motionless, staring at the table. Dr. Cho, who was this message addressed to? The recipient was listed as Mom, which would be Madison's biological mother, Brenda Reeves. When was this message composed? December 29th, 2020, 2 days before the fire. But it was never sent. Correct. It remained in the drafts folder. In your opinion, Dr. Cho, what does this message indicate? It indicates premeditation, motive, and intent. The phrase, tonight, I take back control, and tonight, they learn what happened suggests Madison was planning to do something significant. Combined with the search history about arson, it's clear she was planning to set the fire. Lipsky's cross-examination was brief and ineffective. He tried to argue that the searches were just curiosity and that the text message was venting, but it rang hollow. On day 4, Marsh called the convenience store clerk who had sold Madison snacks 18 minutes after the fire started. The clerk testified that Madison had seemed completely normal, not upset or panicked at all. On day 5, Marsh called the medical examiner, Dr. Patricia Green. Dr. Green was a woman in her late 50s with silver hair pulled back in a bun, a somber expression, and the clinical demeanor of someone who had performed thousands of autopsies. She took the stand and explained the causes of death for each victim. Lucas Hartley died from smoke inhalation, Dr. Green testified. He had elevated levels of carbon monoxide in his blood, consistent with breathing and smoke. He likely lost consciousness quickly and died before the flames reached him. Dr. Green, Marsh asked gently, would Lucas have suffered? Dr. Green's expression softened. Smoke inhalation is extremely painful. The smoke would have burned his airways, made it difficult to breathe. He would have been conscious and aware for several minutes before losing consciousness. He would have been terrified. Several jurors wiped their eyes. Dr. Green continued through each victim. Emma had died from smoke inhalation and carbon monoxide poisoning. Robert and Susan had died from a combination of smoke inhalation and thermal injuries, burns so severe that their skin had blistered and charred. Dr. Green, Marsh asked, in your professional opinion, did any of these victims die painlessly? No. They all suffered before they died. By the time Marsh rested the prosecution's case after 9 days of testimony, she had presented overwhelming evidence of Madison's guilt. The search history, the unsent text message, the gas cans, the surveillance footage, the forensic evidence, the witness testimony. It was a case so strong that even Madison's own attorneys knew they had almost no chance of winning. The defense's case. The defense's case lasted only 2 days. On day 10, Aaron Lipsky called Dr. Helen Morris, a clinical psychologist who had evaluated Madison. Dr. Morris was in her early 60s, with gray hair, kind eyes, and a gentle manner. She testified about Madison's history of trauma, abandonment, and neglect. Dr. Morris, Lipsky asked, Can you explain to the jury what complex PTSD is? Complex PTSD is a psychological condition that develops in people who have experienced prolonged, repeated trauma, particularly during childhood. Unlike regular PTSD, which typically results from a single traumatic event, complex PTSD results from ongoing trauma such as chronic abuse, neglect, or abandonment. Did you diagnose Madison Reeves with complex PTSD? Yes, I did. What were the symptoms you observed? Madison exhibits emotional numbing, difficulty forming attachments, feelings of worthlessness and shame, and difficulty regulating emotions. These are all consistent with complex PTSD resulting from her childhood experiences. Dr. Morris, in your professional opinion, was Madison capable of understanding the consequences of her actions on New Year's Eve? Intellectually, yes. Madison is of average intelligence and understands cause and effect. But emotionally, she was severely impaired. She was in a state of emotional crisis, and her ability to think rationally and make good decisions was significantly compromised. On cross-examination, Ellen Marsh systematically dismantled Dr. Morris's testimony. Dr. Morris, you testified that Madison was emotionally impaired, but she was capable of planning for 6 weeks, correct? Yes. She was capable of researching arson techniques? Yes. She was capable of purchasing gas cans and hiding them? Yes. She was capable of writing a detailed text message explaining her motives? Yes. She was capable of choosing a specific date, New Year's Eve, because house fires are common on holidays? Yes. So, despite her alleged emotional impairment, she was capable of sophisticated planning and deception? Dr. Morris hesitated. Her intellectual functioning was intact, but her emotional functioning was not. Dr. Morris, isn't it true that many people with complex PTSD manage to live their entire lives without murdering anyone? Yes, that's true. No further questions. The defense's only other witness was Linda Paulson, Madison's former caseworker. Paulson testified tearfully about the failures of the foster care system, about how she had been overwhelmed with a caseload of 60 children, about how she had missed warning signs. But on cross-examination, Marsh made clear that Madison had never asked for help, never threatened the Hartleys, never given any indication that she was planning violence. After just 2 witnesses, the defense rested. Closing arguments. On November 1, 2021, Ellen Marsh delivered her closing argument. She stood before the jury and methodically reviewed every piece of evidence: the search history, the text message, the gas cans, the surveillance footage, the forensic evidence. She reminded them of the victims, Robert, Susan, Lucas, and Emma, and the suffering they had endured. 4 people are dead, Marsh said, her voice rising with emotion. 4 innocent people who opened their home to someone in need, who tried to help, who showed kindness. And Madison Reeves murdered them. The evidence is overwhelming. The verdict must be guilty. Aaron Lipsky's closing was emotional, but ultimately unconvincing. He spoke about trauma, about the foster care system's failures, about compassion and rehabilitation. But the jury had already made up their minds. Deliberation and verdict. The jury deliberated for 6 hours. In the jury room, they reviewed the evidence methodically. They looked at the photographs. They reviewed the search history. They read the unsent text message over and over again. She planned this for 6 weeks, said Juror #3, Margaret Chen, the retired postal worker. This wasn't a moment of crisis. This was calculated. But she's just a kid, said Juror #7, Amanda Fisher, the graphic designer. She's been through so much. That doesn't give her the right to kill 4 people, said Juror #8, Robert Hayes, the accountant. Trauma doesn't excuse murder. They took a preliminary vote. 10 guilty, 2 undecided. After another hour of discussion, they took another vote. 12 guilty. They returned to the courtroom. On the count of aggravated murder in the death of Robert Hartley, how do you find? Guilty. On the count of aggravated murder in the death of Susan Hartley, how do you find? Guilty. On the count of aggravated murder in the death of Lucas Hartley, how do you find? Guilty. On the count of aggravated murder in the death of Emma Hartley, how do you find? Guilty. Madison showed no reaction. She sat perfectly still, her face blank, as if the verdict had been handed down for someone else. Sentencing. 2 weeks later, Judge Torres held the sentencing hearing. Michael Hartley, Robert's brother, stood at the podium and read a victim impact statement, his voice breaking. "My brother was the best man I knew," he said. "He was kind, generous, and he loved his family more than anything. Madison Reeves took him from us. She took Susan, Lucas, and Emma from us. And for what? Because she was angry, because she felt abandoned. We all feel pain. We all suffer, but we don't murder innocent people. I hope she spends the rest of her life in prison thinking about what she—" Patricia Monroe, Susan's sister, spoke next, sobbing as she described her sister's kindness and the hole her death had left in the family. When it was Madison's turn to speak, her right of allocution, she stood slowly. Lipsky had coached her, had begged her to show remorse, to apologize, to say something that might convince the judge to show mercy. Madison stood at the defense table, looked at Judge Torres, and said nothing. After 30 seconds of silence, she sat back down. Judge Torres addressed her directly. "Madison Reeves, you have been convicted of 4 counts of aggravated murder, the most serious crime under Oregon law. You planned this crime for weeks. You purchased materials. You waited for the right moment. And then you executed your plan, knowing that innocent people would die. Robert and Susan Hartley opened their home to you. They gave you shelter, food, and care. And you repaid them with murder. You killed 2 children, Lucas and Emma, who had done nothing to you, who had their whole lives ahead of them. I have presided over many cases in my career, but I have rarely encountered such callous disregard for human life." Torres paused, his expression grave. "I hereby sentence you to 60 years to life in prison on each count, to be served consecutively. That means you will serve a total of 240 years, with eligibility for parole after 60 years. You will be 77 years old before you have any chance of freedom. Bailiff, please remand the defendant into custody." Madison was led out of the courtroom in handcuffs. She never looked back. Epilogue. Where they are now. Madison Reeves is currently incarcerated at Coffee Creek Correctional Facility in Wilsonville, Oregon. She is housed in general population and has not participated in any rehabilitation programs. She has granted no interviews and has shown no remorse for her actions. According to prison records, she spends most of her time alone in her cell, reading and writing in journals that she refuses to share with anyone. The Hartley family is remembered through the Robert and Susan Hartley Memorial Scholarship, established by Michael Hartley and Patricia Monroe. The scholarship provides financial support to former foster children pursuing higher education, in the hope that other kids in the system might have the opportunities Madison was given, and might make better choices. Brenda Reeves, Madison's biological mother, declined to comment on the case and has not visited Madison in prison. According to public records, she still lives in California and has had no contact with her daughter since abandoning her in 2014. Detective Carla Winters retired from the Portland Police Bureau in 2023 and now works as a consultant on cold cases. She has never forgotten the Hartley case and says it remains one of the most heartbreaking investigations of her career. Fire Marshal Derek Coleman continues to work in arson investigation and frequently speaks at conferences about the Madison Reeves case as a cautionary tale of missed warning signs and the devastating consequences of untreated trauma. Aaron Lipsky continues to work as a public defender. The Reeves case took a significant toll on his mental health, and he took a 6-month leave of absence after the trial. He has since returned to work, but says he will never forget Madison or the family she destroyed. Ellen Marsh continues to serve as a senior prosecutor in the Multnomah County District Attorney's Office. She has prosecuted over 40 murder cases in her career and considers the Reeves case one of the most clear-cut and most tragic. And in a small cemetery in southeast Portland, 4 headstones stand side by side. Robert Hartley, 1978 to 2020. Beloved husband, father, brother, daughter. Susan Hartley, 1982, 2020. Beloved wife, mother, sister, healer daughter. Lucas Hartley, 2009, 2020. Forever in our hearts. Emma Hartley, 2012, 2020. Our little artist, taken too soon. They are visited regularly by family members, by friends, and by strangers who have followed the case and want to pay their respect. The Hartley home was demolished in March 2021. The lot remains empty, a reminder of the tragedy that occurred there, and the 4 lives that were lost on a New Year's Eve that should have been filled with hope and celebration. Justice was served. But nothing can bring them back.